In the previous section, that is lesson 3, part 3, subpart 1, we introduced our viewers to the 3 ways of securing the presence of an accused at his trial, such as arrest without warrant, arrest with warrant, and summons. Next, we listed 12 examples of high-profile arrests that will be analyzed to understand what constitutes a lawful arrest. We zeroed in on Omoyele's arrest by the State Security Service on August 3, 2019. We also defined arrest and the power of arrest before going on to review all constitutional provisions on the power of arrest, as well as provisions of procedural law on arrest. Then we concluded with comparative law by analyzing UK law on arrests. In this section of the video, we will be zeroing in on the power of arrest without a warrant. Here is a breakdown of what we will be considering. Who can arrest without a warrant? Arrest without a warrant by the police. I will take case law and statutory law from the ACJA, the ACJL, the CP, and the CPC. Next, arrest without a warrant by private persons. There are 3 categories of persons that have the power of arrest without a warrant. These are the police, judicial officers, and private persons. We will now consider 5 cases on arrest without a warrant by the police. Let's run down the cases we'll be considering. IGP versus Ogbomo, Jackson versus Omorokuna, Commissioner of Police Ondo State versus Obolo, Wiltshire versus Barrett, Dallison versus Caffery. IGP versus Ogbomo affirmed the power of the police to arrest without a warrant. However, this mode of arrest shall not apply to any offence wherein it is provided that the offender may not be arrested without a warrant. According to this case, the reasonable grounds on which a police officer can arrest may be based on either 1. Facts within his knowledge. 2. Facts stated to him by another. The plaintiff and another person were seen at night in a crime-prone area dragging a motorcycle. The key and particulars to which the door could not produce on demand. When the defendant demanded for the particulars and the ignition keys, the plaintiff and his colleague could not produce them. The defendant arrested them and took them to the police station where they were detained. Upon their release, the plaintiff brought this action against the defendant for unlawful arrest and false imprisonment. The court held that the circumstances of the plaintiff's arrest were such that it cannot be said that the defendant has no reasonable ground to suspect the plaintiff and the other person. This case is often cited as proof that provided that if a police officer has reasonable grounds for effecting an arrest, the fact that the arrest is without warrant is not a material consideration or sufficient basis to claim that the arrest is in breach of the law. Indeed, an arrest made in such circumstances is lawful. In Commissioner of Police Ondo State vs. Obolo, the plaintiff respondent was routinely picked up as a suspect whenever there was a case of robbery. He applied and obtained leave of the High Court to enforce his fundamental rights against the police to show cause why his right to personal liberty should be breached by being unconstitutionally and unlawfully arrested and detained on diverse dates without being informed of the offence he had committed, charged, or brought before a court of competent jurisdiction. On appeal, the Court of Appeal held that the fundamental rights of the respondent had been infringed without reasonable and probable cause. Damages of 17,500 naira was awarded for the unlawful arrest and detention of the respondent. In this case, Salami JCA, as he then was, delivered the judgment of the Court of Appeal and stated the law as follows. The tests as to what is reasonable belief the respondent has committed an offence is objective. It is not what the appellant considered reasonable, but whether the facts within their knowledge at the time of the arrest disclose circumstances from which it could easily be inferred that the respondent committed the offence. See Oteri versus Okorodudu, a 1970 case. The burden of proving the legality or constitutionality of the arrest and the imprisonment is on the appellants. This cannot be successfully done without disclosing to the trial court in their counter affidavit what the respondent did. The wrong assumption is that it was for the respondent to show that the arrest was unlawful. It is a matter for the court to determine whether or not there is a good ground for the arrest, and it cannot do so if the party who knew the reasonable ground for arresting the respondent holds onto it. In summary, it was held that the arrest of the plaintiff respondent was unlawful because it was not founded on reasonable grounds but baseless suspicion. From the above analysis, the test for reasonable grounds or reasonable suspicion is an objective one. Put another way, the real question is this: is there a good reason why the individual should be arrested? If the answer is yes, then the arrest is lawful. In Wiltshire vs. Barrett, the plaintiff claimed damages against the police constable of the Southampton Police Force for assault and battery. The action gave rise to very important questions as to the powers of arrest possessed by a police constable when he sees a person driving a motor vehicle and that person appears to him unfit to do so by reason of drink or drugs. The circumstances in which this action was brought were that the defendant and another police constable saw the plaintiff driving at what they considered to be an excessive speed. They signaled him to stop, which he did. The defendant then asked the plaintiff for his name and address, to which he made no reply. He was asked several times to get out of his car, but the plaintiff clung to the steering with his feet pressed against the floor of the car and said that he was not moving. The two officers stated that the plaintiff was staring ahead with a glassy look in his eyes. They radioed for assistance, and with the help of two other officers, the plaintiff was taken to a police station. It was an issue whether the plaintiff was ever told he was being arrested for driving under the influence of drink. At the police station, the plaintiff was examined by a doctor who found a number of bruises and abrasions on him, but expressed the opinion that he was not unfit to drive. The officer in charge of the station released the plaintiff from custody without his having been charged or entering recognizances. The plaintiff was told that a report would be sent to the Chief Constable of Southampton, who a few days later informed the plaintiff that no proceedings would be taken against him. This case established that a constable's power of arrest without warrant is exercisable on reasonable suspicion, and that he must use only a reasonable amount of force to effect their arrests. It is for the detaining authority to justify all periods of detention. The court described the common law duty on a prosecutor to disclose material. Lord Denning, Master of the Rolls, said, "The duty of a prosecuting counsel or solicitor, as I have always understood it, is this: if he knows of a credible witness who can speak to material facts which tend to show the prisoner to be innocent, he must either call that witness himself or make his statement available to the defense. It would be highly reprehensible to conceal from the court the evidence which such a witness can give. If the prosecuting counsel or solicitor knows not of a credible witness, but a witness whom he does not accept as credible, he should tell the defense about him so that they can call him if they wish." Here the solicitor, immediately after the court proceedings for committal before the magistrates, gave the solicitor for the defense the statement of Mr. and Mrs. Stamp, and thereby he did his duty. Diplock LJ said that it is for the trial judge objectively to determine whether the suspicion held by a police officer and used to justify an arrest was reasonable, and that whether there are such grounds or not is a question of law. The tests whether there was a reasonable and probable cause for the arrests or prosecution is an objective one. Namely, whether a reasonable man assumed to know the law and possessed of the information which in fact was possessed by the defendant would believe that there was reasonable and probable cause. He then spoke on the continuing nature of an arrest. The trespass by the arrestor continues so long as he retains custody of the arrested person, and he must justify the continuance of his custody by showing that it was reasonable. What is reasonable conduct on the part of a police officer in this respect may not be the same as what would be reasonable conduct on the part of a private arrestor. We are now done with case law and have now moved on to statutory law. The statute discloses 15 grounds or bases for arrests without warrants by the police. Those 15 grounds can be distilled from the following provisions: Section 18, subsection 1 of the ACJA, Section 10, subsection 1 of the ACJL, Section 10, subsection 1 of the CPA, and Section 26 of the CPC. The 15 grounds or basis for arrest without warrant by the police include suspicion on reasonable grounds. 2. Committing offence in his presence. 3. Obstruction of duty, attempted escape from custody, or actual escape from custody. 4. Reasonable suspicion of possession of stolen property. 5. Deserter. 6. Crime outside jurisdiction, whether it be Nigeria or a state of Nigeria. 7. Possession of implements used to commit crime. 8. Person against whom a warrant of arrest has been issued. 9. Person concealing his presence with apparent criminal intentions. 10. Someone accused of committing an offence triable summarily and who refuses to disclose his identity and address or provides what the police officer considers is a false identity or address. 11. Someone whom a police officer reasonably suspects of trying to commit a crime where the police officer is of the view that only his arrest can stop the commission of the offence. 12. Someone against whom a public summons has been published or issued. 13. Someone against whom a warrant of arrest has been issued or whom he is directed to arrest. 14. Someone the governor directs the police officer to arrest. 15. Someone charged with a felony or misdemeanor. Ground number 1. Suspicion on reasonable grounds. Let's take the first one, Section 18, Subsection 1A of the ACJA. A police officer may, without an order of a court and without a warrant, arrest a suspect whom he suspects on reasonable grounds of having committed an offence against a law in Nigeria or against the law of any other country, unless the law creating the offence provides that the suspect cannot be arrested without a warrant. Section 10, Subsection 1 of the ACJL states, a police officer may, without an order from a magistrate and without a warrant, arrest a person whom he suspects upon reasonable grounds of having committed an offence, triable on information against a federal law or against the law of the state or against the law of any other state, unless the written law creating the offence provides that the offender cannot be arrested without a warrant. Section 10, Subsection 1A of the CPA states that any police officer may, without an order from a magistrate and without a warrant, arrest any person whom he suspects upon reasonable grounds of having committed an indictable offence against the federal law or against the law of any state or against the law of any other state, unless the written law creating the offence provides that the offender cannot be arrested without a warrant. Section 26 of the CPC states that any police officer may arrest any person whom he reasonably suspects to be designing to commit an offence for which the police may arrest without a warrant, if it appears to him that the commission of the offence cannot be otherwise prevented. Section 24, Subsection 1A and 24, Subsection 1C of the Police Act states, in addition to the powers of arrest without warrant conferred upon a police officer by Section 10 of the Criminal Procedure Act, it shall be lawful for any police officer and any person whom he may call to his assistance to arrest without warrant in the following cases. Any person whom he finds committing any felony, misdemeanor, or simple offence, or whom he reasonably suspects of having committed or being about to commit any felony, misdemeanor, or breach of the peace. C. Any person whom any other person suspects of having committed a felony or misdemeanor, or charges with having committed a simple offence, if such other person is willing to accompany the police officer to the police station and to enter into a recognizance to prosecute such charge. Ground number 2. Committing an offence in his presence. Section 18, subsection 1b of the ACJA states that a police officer may, without an order of the court and without a warrant, arrest a suspect who commits an offence in his presence. Section 10, subsection 1b of the ACJL states a police officer may, without an order from a magistrate and without a warrant, arrest a person who commits an offence in his presence. Section 10, subsection 1b of the CPA states that any police officer may, without an order from a magistrate and without a warrant, arrest any person who commits an offence in his presence. Section 26A of the CPC states that any police officer may arrest any person who commits an offence in his presence, notwithstanding any provision in the third column of Appendix A that an arrest may not be made without a warrant. Section 24, subsection 1A of the Police Act reads in part, in addition to the powers of arrest without warrant conferred upon a police officer by Section 10 of the Criminal Procedure Act, it shall be lawful for any police officer and any person whom he may call to his assistance to arrest without warrant in the following cases: any person whom he finds committing any felony, misdemeanor, or simple offense. Ground number 3. Obstruction of duty, attempted escape from custody, actual escape from custody. Section 18, subsection 1c of the ACJA states, a police officer may, without an order of a court and without a warrant, arrest a suspect who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Section 10, subsection 1c of the ACJL states, a police officer may, without an order from a magistrate and without a warrant, arrest a person who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Section 10, subsection 1c of the CPA states, any police officer may, without an order from a magistrate and without a warrant, arrest any person who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody. Section 26, subsection I and J of the CPC states, any police officer may arrest any person who obstructs a police officer while in the execution of his duty, any person who has escaped or attempts to escape from lawful custody. Ground number 4. Reasonable suspicion of possession of stolen property. Section 18, subsection 1d of the ACJA tells us that a police officer may, without an order of a court and without a warrant, arrest a suspect in whose possession anything is found which may reasonably be suspected to be stolen property, or who may reasonably be suspected of having committed an offense with reference to the thing. Section 10, subsection 1d of the ACJL tells us A police officer may, without an order from a magistrate and without a warrant, arrest a person in whose possession anything is found which may reasonably be suspected to be stolen, or who may reasonably be suspected of having committed an offence with reference to such a thing. Section 10, subsection 1d of the CPA tells us that any police officer may, without an order from a magistrate and without a warrant, arrest any person in whose possession anything is found which may reasonably be suspected to be stolen property, or who may reasonably be suspected of having committed an offence with reference to such a thing. Section 26H of the CPC tells us that any police officer may arrest any person in whose possession property is found which may reasonably be suspected to be stolen property, or property in respect of which an offence has been committed under sections 115, 116, 118, 119, 120, 121, 122, 168, or 169 of the Penal Code, or who may reasonably be suspected of having committed an offence with reference to such property. Ground number 5, deserter. Section 18, subsection 1e of the ACJA tells us that a police officer may, without an order of a court and without a warrant, arrest a suspect whom he suspects on reasonable grounds of being a deserter from any of the armed forces of Nigeria. Section 10, subsection 1e of the ACJL tells us that a police officer may, without an order from a magistrate and without a warrant, arrest a person whom he suspects upon reasonable grounds of being a deserter from any of the armed forces of Nigeria. Section 10, subsection 1e of the CPA tells us any police officer may, without an order from a magistrate and without a warrant, arrest any person whom he suspects upon reasonable grounds of being a deserter from any of the armed forces of Nigeria. Section 26, subsection K of the CPC tells us that any police officer may arrest any person reasonably suspected of being a deserter from any military force for the time being serving in Nigeria. Ground number 6, crime committed outside jurisdiction, whether it be Nigeria as a country or a state of Nigeria. Section 18, subsection 1F of the ACJA tells us that a police officer may, without an order of a court and without a warrant, arrest a suspect whom he suspects on reasonable grounds of having been involved in an act committed at a place outside of Nigeria, which, if committed in Nigeria, would have been punished as an offence, and for which he is, under a law in force in Nigeria, liable to be apprehended and detained in Nigeria. Section 10, subsection 1F of the ACJL states, a police officer may, without an order from a magistrate and without a warrant, arrest a person whom he suspects upon reasonable grounds of having been concerned in an act committed at any place out of the state, which, if committed in the state, would have been punishable as an offence, and for which he is, under any enactment in force in the state, liable to be arrested and detained in the state. Section 10, subsection 1F of the CPA tells us that any police officer may, without an order from a magistrate and without a warrant, arrest any person whom he suspects upon reasonable grounds of having been concerned in any act committed at any place out of Nigeria, which, if committed in Nigeria, would have been punishable as an offence, and for which he is, under any enactment in force in Nigeria, liable to be apprehended and detained in Nigeria. Ground number 7. Possession of implements used to commit crimes. Section 18, subsection 1G of the ACJA tells us a police officer may, without an order of a court and without warrant, arrest a suspect having in his possession without lawful excuse. The burden of proving which excuse shall lie on such person any implement of housebreaking, car theft, firearm, or any offensive or dangerous weapon. Section 10 of Section 1G of the ACJL tells us that a police officer may, without an order from a magistrate and without a warrant, arrest a person having in his possession without lawful excuse any implement of housebreaking, firearm, or any offensive or dangerous weapon. Section 10 subsection 1G of the CPA tells us any police officer may, without an order from a magistrate and without a warrant, arrest any person having in his possession without lawful excuse the burden of proving which excuse shall lie on such person any implements of housebreaking. Ground number 8. Person against whom a warrant of arrest has been issued. Section 18 subsection 1H of the ACJA tells us that a police officer may, without an order of a court and without a warrant, arrest a suspect whom he has reasonable cause to believe a warrant of arrest has been issued by a court of competent jurisdiction in Nigeria. Section 10 subsection 1H of the ACJL tells us that a police officer may, without an order from a magistrate and without a warrant, arrest a person for whom he has reasonable cause to believe a warrant of arrest has been issued by a court of competent jurisdiction in the state. Section 10 subsection 1H of the CPA tells us that any police officer may, without an order from a magistrate and without a warrant, arrests any person for whom he has reasonable cause to believe a warrant of arrest has been issued by a court of competent jurisdiction in the state. Section 26B of the CPC tells us that any police officer may arrest any person for whose arrest a warrant has been issued or whom he is directed to arrest by a justice of the peace or superior officer under Section 29 or 30. Ground number 9. Person concealing his presence with apparent criminal intentions. Section 18 subsection 1I of the ACJA states, a police officer may, without an order of a court and without a warrant, arrest a suspect found in Nigeria, taking precautions to conceal his presence in circumstances which afford reason to believe that he is taking such precautions with a view to committing an offence. Section 10 subsection 1I of the ACJL states a police officer may, without an order from a magistrate and without a warrant, arrest a person found in the state taking precautions to conceal his presence in circumstances which afford reason to believe that he is taking such precautions with a view to committing an offence which is a felony or a misdemeanor. Section 10 subsection 1J of the CPA states any police officer may, without an order from a magistrate and without a warrant, arrest any person found in the state taking precautions to conceal his presence in circumstances which afford reason to believe that he is taking such precautions with a view to committing an offence which is a felony or a misdemeanor. Section 26G of the CPC states any police officer may arrest any person found taking precautions to conceal his presence in suspicious circumstances, or who, being found in suspicious circumstances, has no ostensible means of subsistence or cannot give a satisfactory account of himself. Ground 10. Someone accused of committing an offence triable summarily and who refuses to disclose his identity and address or provides what the police officer considers as a false identity or address. Section 19, subsection 1 of the ACJA tells us that where a suspect who, in the presence of a police officer, has committed or has been accused of committing an offence triable summarily, refuses on demand of the officer to give his name and residential address, or gives a name or residential address which the officer has reason to believe to be false, he may be arrested by the officer in order that his name or residential address may be ascertained. Section 11, subsection 1 of the ACJL tells us that when a person who, in the presence of a police officer, has committed or has been accused of committing an offence triable summarily, refuses on demand of the officer to give his name and residence, or gives a name or residence which the officer has reason or gives a reason to believe to be false, he may be arrested by the officer in order that his name or residence may be ascertained. Section 11, subsection 1 of the CPA, when any person who in the presence of a police officer has committed who has been accused of committing a non-indictable offence, refuses on demand of such officer to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained. Section 26L of the CPC, any person who in his presence has committed or been accused of committing any offence for which the police may not, according to the third column of Appendix A, arrest without a warrant if on his demand such person refuses to give his name and address, or gives a name and address which he believes to be a false one. Ground 11. Someone whom a police officer reasonably suspects of trying to commit a crime, and the police officer is of the view that only his arrest can stop the commission of the offence. Section 52 of the ACJA states that notwithstanding the provisions of this Act or any other law relating to arrest, a police officer, upon a reasonable suspicion of a design to commit an offence, may arrest without orders from a magistrate and without warrant the suspect where it appears to the officer that the commission of the offence cannot otherwise be prevented. Section 54 of the ACJL states, notwithstanding the provisions of this law or any other written law relating to arrest, a police officer, knowing of a design to commit any offence, may arrest without order from a magistrate and without warrant the person so designing, if it appears to such officer that the commission of the offence cannot otherwise be prevented. Section 55 of the CPA states, notwithstanding the provisions of this law or any other written law relating to arrest, a police officer, knowing of a design to commit any offence, may arrest without orders from a magistrate and without a warrant the person so designing, if it appears to such officer that the commission of the offence cannot otherwise be prevented. Ground number 12. Someone against whom a public summons has been published or issued. Section 18, subsection 1L of the ACJA tells us a police officer may, without an order of a court and without a warrant, arrest a suspect required to appear by a public summons issued under this Act or any other Act. Section 26F of the CPC tells us that any police officer may arrest any person required to appear by a public summons published under Section 67. Ground number 13. Someone against whom a warrant of arrest has been issued or whom he is directed to arrest. Section 18, subsection 1J of the ACJA tells us that a police officer may, without an order of a court and without a warrant, arrest a suspect whose arrests a warrant has been issued or whom he is directed to arrest by a judge, a magistrate, a justice of the peace, or superior police officer. Ground number 14. Someone the governor directs the police officer to arrest. Section 26, subsection M of the CPC states that any police officer may arrest any person failing to obey a direction the governor issued under Section 303. Ground number 15. Someone charged with a felony or misdemeanor. Section 24, subsection 1B of the Police Act states, in addition to the powers of arrest without warrants conferred upon a police officer by Section 10 of the Criminal Procedure Act, it shall be lawful for any police officer and any person whom he may call to his assistance to arrest without warrant in the following cases: any person whom any other person charges with having committed a felony or misdemeanor. This brings us to the end of our consideration of arrest without a warrant by the police. This also means we can switch to arrest without a warrant by judicial officers. On the screen you can see that we're looking at it from the ACJA angle, the ACJL angle, the CPA angle, the CPC angle, and the case law angle. For the ACJA, you'll be depending on Section 24, Section 25, subsection 1, and 25, subsection 2, Section 26, and Section 27. For the ACJL, we'll be looking at Section 15, Section 16 sub 1 and 16 sub 2, as well as Section 33. For CPA, we're looking at Section 15, Section 16 sub 1 and 16 sub 2, as well as Section 34. For the CPC jurisdiction, we're looking at Section 29 subsection 1 and 29 subsection 2, as well as 30 subsection 1 and 30 subsection 2. And case law will take us to Onitiri vs. Ogbomo. It's a 1954 case. Arrest without a warrant by judicial officers. In the ACJA jurisdiction, the relevant sections are Section 24, Section 25, 26, and 27. Section 24 has the headline Offence committed in presence of judge or magistrate. Where an offence is committed in the presence of a judge or magistrate, within the division or district in which the judge is sitting, or to which the magistrate is assigned, the judge or magistrate may himself arrest or order a person to arrest the suspect and may thereupon, subject to the provisions contained in this Act as to bail, commit the suspect to custody. Section 25 is headlined Arrest by Magistrate. 25 subsection 1 reads, a magistrate may arrest or direct the arrest in his presence of a suspect whose arrest on a warrant he could have lawfully ordered if the facts known to him at the time of making or directing the arrest had been stated before him on oath by some other person. 25 subsection 2 reads, where a suspect is arrested in accordance with the provisions of either section 23 or 24 of this Act, the judge or magistrate making or directing the making of such arrest may deal with the suspect in the same manner as if the suspect had been brought before him by or under the directions of any other person. Section 26 is headlined Arrest for offence committed in presence of judge, magistrate, or justice of the peace, and states a judge, magistrate, or justice of the peace may arrest or direct the arrest of a suspect committing an offence in his presence and shall thereupon hand him over to a police officer who shall proceed to take necessary action. Section 27 headlined When public is bound to assist in arrest. A person is bound to assist a judge, magistrate, justice of the peace, police officer, or other person reasonably demanding his aid in arresting or preventing the escape of a suspect whom the judge, magistrate, justice of the peace, police officer, or other person is authorized to arrest. In ACJL jurisdiction, the relevant sections are section 15, 16, 29, and 33. Section 15 is headlined Offence committed in presence of a judge or magistrate. It states, when an offence is committed in the presence of a judge or magistrate, the judge or magistrate may himself arrest or order any person to arrest the offender and may, subject to the provisions of this law relating to bail, commit the offender to custody. Section 16 is headlined Arrest by a judge or magistrate. 16 subsection 1 states, a judge or magistrate may arrest or direct the arrest in his presence of a person whose arrest upon a warrant he could have lawfully ordered if the facts known to him at the time of making or directing the arrest had been stated before him on oath by some other person. 16 subsection 2 states, where a person is arrested in accordance with the provisions of subsection 1 of this section, the judge or magistrate making or directing the making of such arrest may deal with the person so arrested in the same manner as if the person had been brought before him by or under the directions of any other person. Section 33 is headlined Assistance to Judge, Magistrate, or Police Officer and states, every person is bound to assist the judge, magistrate, or police officer reasonably demanding his assistance in arresting or preventing the escape of any other person whom the judge, magistrate, or police officer is authorized to arrest, prevention or suppression of a breach of the peace, or in the prevention of any injury or damage attempted to be committed on any person or any property. In CPA jurisdiction, the relevant sections are section 15, 16, and 34. Section 15 states, When any offence is committed in the presence of a judge or magistrate within the division or district in which such judge is sitting, or to which such magistrate is assigned, such judge or magistrate may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. Section 16, subsection 1 states, within the district to which he is assigned, any magistrate may arrest or direct the arrest in his presence of any person whose arrest upon a warrant he could have lawfully ordered if the fact known to him at the time of making or directing the arrest had been stated before him on oath by some other person. 16 subsection 2 states, where a person is arrested in accordance with the provisions of either section 15 or 16 of those acts, the judge or magistrate making or directing the making of such arrest may deal with the person so arrested in the same manner as if such last named person had been brought before him by or under the directions of any other person. Section 34 states that every person is bound to assist a judge or magistrate or police officer reasonably demanding his aid in the taking or preventing the escape of any other persons whom such magistrate or police officer is authorized to arrest, in the prevention or suppression of a breach of the peace, or in the prevention of any injury attempted to be committed to any telegraph or public property. In CPC jurisdiction, the relevant sections are sections 29 and 30. Section 29 is headlined Arrest for Offence Committed in Presence of Justice of the Peace. 29 subsection 1 states, any justice of the peace may arrest or direct the arrest of any person committing any offence in his presence, and shall thereupon hand him over to a police officer or take security for his attendance before a court at a specified time. 29 subsection 2 states, notwithstanding the provisions of subsection 1, a justice of the peace shall not direct a superior police officer under this section. Section 30 is headlined Arrest by or in presence of justice or superior police officer. 30 subsection 1 states, any justice of the peace or superior police officer may at any time arrest or direct the arrest in his presence of any person for whose arrest a warrant might lawfully be issued. 30 subsection 2, a justice of the peace making an arrest under subsection 1 shall thereupon hand over the person arrested to a police officer or take security for his attendance before a court at a specified time. However, the provisions of the CPC notwithstanding, the rule of practice is that magistrates and judges in states that are governed by the CPC do actually exercise the same powers of arrest without warrant in the same circumstances as their counterparts do under the CPA. In other words, we have what is known as the rule of law and the rule of practice, which I have just described. In this case, the defendant magistrate was presiding at the court where the plaintiff was a party in a certain proceeding. The plaintiff had applied to transfer the case from the defendant's court. Upon reading a paragraph of his application for transfer at the request of the defendant, the plaintiff was informed by the defendant that he had committed a contempt of court. The defendant formulated a charge against him and remanded him in custody, pending his trial before another magistrate. Subsequently, the plaintiff instituted an action against the defendant claiming damages for unlawful imprisonment. It was held by the court per D. Command SPJ that the defendant was entitled to immunity under the then Section 6 subsection 1 of the Magistrates Court Ordinance, which provided that no magistrate, justice of the peace, or other person acting judicially shall be liable to be sued in any civil court for any act done or ordered to be done by him in the discharge of his judicial duty, whether or not within the limits of his jurisdiction, provided that he at the time, in good faith, believe himself to have jurisdiction to do or order the act complained of. It was further held that a magistrate can arrest or order the arrest of any person whom he reasonably suspects of having committed an offence. The court came to that conclusion while interpreting what has come to be known as Section 15 of the CPA. We have concluded arrest without a warrant by judicial officers. We are now turning attention to arrest without a warrant by private persons. As is our practice, we'll be looking at it from the angle of the ACJA, the ACJL, the CPA, the CPC, as well as case law. Sections 20, 21, and 23 are the relevant sections for the ACJA. Sections 12, 13, and 14 are relevant for ACJL. Sections 12, 13, and 14 relevant for CPA. Sections 28, 29, 30, and 39 are relevant for CPC. We'll be looking at Nweke versus the State, John Lewis and Co. Limited versus Teams, Abdullahi versus Bono Native Authority, and Dallison versus Caffery. Section 20 of the ACJA is headlined Arrest by a Private Person and states, a private person may arrest a suspect in Nigeria who in his presence commits an offence, or whom he reasonably suspects of having committed an offence for which the police is entitled to arrest without a warrant. Section 21 of the ACJA is headlined Arrest by owner of property. A suspect found committing an offence involving injury to property may be arrested without a warrant by the owner of the property or his servants, agents, or persons authorized by him. Section 22 is headlined Arrest of suspect doing damage to public property. A private person may arrest any suspect found damaging public property. Section 23 is headlined Handing over of an arrested suspect by private person. 23 subsection 1 states, a private person who arrests a suspect without a warrant shall immediately hand over the suspect to a police officer, or in the absence of a police officer, shall take the suspect to the nearest police station, and the police officer shall make a note of the name, address, and other particulars of the private person making the arrest. 23 subsection 2 states, where there is reason to believe that the arrested suspect comes under the provisions of Section 18 subsection 1, a police officer shall re-arrest him. 23 subsection 3, where there is reason to believe that the suspect has committed the offence and he refuses on the demand of a police officer to give his name and address, or gives a name or address in which the police officer reasonably believes to be false, shall be dealt with under the provisions of Section 19 of this Act. Section 23 subsection 4 states, where a suspect so arrested by a private person is handed over to a police officer or to an official of an agency authorized by law to make arrests, the police officer or official shall take note of the name, residential address, and other particulars of the private person making the arrest, and the date, time, and other circumstances of the arrest, and where the arrested suspect is taken to the police station or to the agency, the charge room officer shall make the entries in the crime diary. Section 23 subsection 5 states, the police officer or official to whom the arrested suspect is handed over by the private person shall obtain from the private person who made the arrest a formal witness statement setting out the facts and circumstances of the arrests. Section 23 subsection 6, where there is sufficient reason to believe that the suspect handed over has committed an offence, he shall immediately be rearrested. But if there is no sufficient reason to believe that the suspect has committed an offence, he shall be released immediately. 23 subsection 7. The provisions of section 15 of this Act do not apply to this section unless the suspect arrested and handed over has been rearrested in accordance with subsection 2 of this section. But compare section 27, which makes citizens duty bound to assist a judge, magistrate, justice of the peace, police officer, or other person in effecting an arrest. Arrests without a warrant by private persons in the ACJL jurisdiction. For the ACJL jurisdiction, the relevant sections are sections 12, 13, and 14. Section 12 of the ACJL is headlined Arrest by Private Persons. 12 subsection 1 reads, a private person may arrest any person who commits an offence triable on information in his presence, or whom he reasonably suspects of having committed an offence triable on information. 12 subsection 2. After the arrest of the person under subsection 1 of this section, a private person shall not subject the arrested person to torture, inhuman, or degrading treatment. Section 13 is headlined Arrests by Owners of Property. 13 subsection 1 states, a person found committing an offence involving damage to property may be arrested without a warrant by the owner of the property or his servants or persons authorized by him. 13 subsection 2, a private person may arrest any person found damaging public property. Section 14 is headlined Treatment of person arrested by private person. 14 subsection 1 states, a private person who arrests any other person without a warrant shall without unnecessary delay hand over the person arrested to a police officer, or in the absence of a police officer shall take the person to the nearest police station. 14 subsection 2. The police officer shall make a note of the name, residence, and other particulars of the private person making the arrest. 14 subsection 3. The private person making the arrest shall make a statement of the circumstances of the arrest. 14 subsection 4. Where there is reason to believe that such person comes under the provisions of subsection 1 of section 3, a police officer shall re-arrest him. 14 subsection 5. If there is reason to believe that he has committed an offence triable on information and refuses on the demand of a police officer to give his name and residence, or gives a name or residence which the officer has reason to believe to be false, he shall be dealt with under the provisions of section 11. If there is no sufficient reason to believe that he has committed an offence, he shall be released at once. For CPA jurisdiction, the relevant sections are sections 12, 13, and 14. Section 12 of the CPA states that any private person may arrest any person in a state who, in his view, commits an indictable offence or whom he reasonably suspects of having committed an offence which is a felony, or of having committed by night an offence which is a misdemeanor. Section 13. Persons found committing any offence involving injury to property may be arrested without a warrant by the owner of the property or his servants or persons authorized by him. Section 14, subsection 1. Any private person arresting any other person without a warrant shall, without unnecessary delay, make over the person so arrested to a police officer, or in the absence of a police officer shall take such person to the nearest police station. 14 subsection 2. If there is reason to believe that such person comes under provisions of subsection 1 of section 10 of this Act, a police officer shall re-arrest him. 14 subsection 3. If there is reason to believe that he has committed an indictable offence, and he refuses, on the demand of a police officer, to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, shall be dealt with under the provisions of section 11 of this Act, and if there is no sufficient reason to believe that he has committed any offence, he shall be at once released. In CPC jurisdiction, the relevant sections are sections 28, 29, 30, and 39. Section 28 is headlined, "When private person may arrest." It states, any private person may arrest A. Any person for whose arrest he has a warrant or whom he is directed to arrest by a justice of the peace under section 29, or by a justice of the peace or a superior police officer under section 30. B. Any person who has escaped from his lawful custody. C. Any person required to appear by a public summons published under section 67. D. Any person committing in his presence an offence for which the police are authorized to arrest without a warrant. Section 29 is headlined, "Arrest for offence committed in presence of justice of the peace." 29 subsection 1 states, any justice of the peace may arrest or direct the arrest of any person committing any offence in his presence, and shall thereupon hand him over to a police officer, or take security for his attendance before a court at a specified time. 29 subsection 2. Notwithstanding the provisions of subsection 1, a justice of the peace shall not direct a superior police officer under this section. Section 30 is headlined, "Arrest by or in presence of justice of the peace or superior police officer." Section 30 subsection 1 states, any justice of the peace or superior police officer may at any time arrest or direct the arrest in his presence of any person for whose arrest a warrant might lawfully be issued. 30 subsection 2. A justice of the peace making an arrest under subsection 1 shall thereupon hand over the person arrested to a police officer or take security for his attendance before a court at a specified time. Section 39 is headlined, "Procedure after arrest by a private person." 39 subsection 1 states, any person, except a police officer or a justice of the peace, making an arrest without a warrant or an order of a justice of the peace, shall without unnecessary delay take the person arrested to the nearest police station or hand him over to a police officer. Section 39 subsection 2. If the arrested person appears to be one whom the police officer is authorized to arrest, the police officer shall re-arrest him. Otherwise, the arrested person shall be at once released. Our first case law is Nweke versus the state. This case is an authority for the fact that a private person is deemed to have the power to effect the arrest of a person whom a private person reasonably suspects of having committed a felony. A private person can become guilty of breaking the law if he takes an inordinate amount of time to hand over the subject of a private person arrest without a warrant to a police officer. Such a private person stands the risk of an award of damages for false imprisonment. The use of the right of self-defense as a legal justification is not available to a person who forcefully resists his arrest by a private person. In Dallison vs. Caffery, Diplock LJ spoke on the continuing nature of an arrest. The trespass by the arrestor continues so long as he retains custody of the arrested person, and he must justify the continuance of his custody by showing that it was reasonable. What is reasonable conduct on the part of a police officer in this respect may not be the same as what would be reasonable conduct on the part of a private arrestor. The import of this ruling is that a private person can become guilty of breaking the law if it takes an inordinate amount of time to hand over the arrested person to a police officer, and if a police officer is not close by, he is duty-bound to take the arrested person to the nearest police station.